regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. Going to be talking with Jim Wallace from the Gun Owners Action League up in Massachusetts here in just a second. Jim was kind enough to send over a couple of items the other day that just blew my mind. I mean, and I know that Massachusetts is one of the worst states in the country when it comes to recognizing our Second Amendment rights, but these cases are so egregious, so bizarre in terms of treating our Second Amendment rights as privileges, right? And that essentially is what Massachusetts does. You don't start with your right to keep and bear arms, and then depending on, your criminal activity, you lose that right. You start basically with a prohibition on you being able to exercise your right to keep and bear arms. And if you are deemed suitable by the authorities, then you get your Second Amendment permission slip. Otherwise, you don't have any Second Amendment rights. And honestly, even after you get your Second Amendment permission slip, you don't have any Second Amendment rights because that permission slip can be taken away for virtually any reason that a licensing authority decides makes you unsuitable to possess a firearm. There are a number of cases in Massachusetts right now where the suitability language is an issue. And again, Gun Owners Action League highlighting a couple of the worst abuses. Makes for great talk show fodder, I'll tell you that, but it does not make for a state where your rights are safe and secure in the slightest. Take a look and a listen. Jim, thank you so much for coming on the program. It's good to see you again.
Well, I wish it was a good news day, but, welcome back to the Second Amendment battleground state again.
Yeah, this is, and this is absolutely crazy. We're going to be talking with Toby Leary on the program tomorrow. And of course, for folks who don't know, Toby is the head of the Civil Rights Coalition, which is the group that is challenging Chapter 135. They've got a ballot measure coming up in November that would repeal Chapter 135. And one of the many provisions of Chapter 135, this is the part of the difficulty, Jim, is there's no way to explain all of the problems with this law in 30 seconds. Or 60 seconds. You can't run just a normal TV commercial. One of the things that changed with Chapter 135, correct me if I'm wrong about any of this, it used to be that if a police chief or licensing authority said, hey, I've got my concerns about you, we're going to suspend your license. If you appealed that decision, the license suspension was essentially stayed. You got to keep a hold of your firearms while this process played out. That's no longer the case, right?
Yeah, actually, it's never been the case, unfortunately. So we had in Massachusetts what was called suitability,
right?
Which if the chief licensing officer or whatever didn't like you because you dated his cousin, he could suspend or revoke your license. Bruin said, no, you can't use suitability. You have to use X, Y, and Z. So Massachusetts immediately codified suitability. And all they said was it has to be, I think it's credible and reliable information. So because they codified it, they now think it's still constitutional. Well, there's a lot of things that are illegal and unconstitutional, but just because you codify them doesn't mean it's okay.
Right.
So what happens here is if you're nailed under the codified suitability clause, you have to surrender your guns. You have only 90 days to appeal, and most people have no idea that's the case. And if you don't, you have to go through the entire licensing process again. Take your extended course now, get all that stuff done, and It's hundreds and hundreds of dollars. Or you can pay probably $5,000 to $6,000 and appeal it in district court. And there are actually occasions where the judge says, yes, give them the license back, and the town still refuses to do it because they say they're the licensing authority and they don't answer to the courts.
Oh, wow. That is That I mean, so again, so this is the process, and
Yeah.
you all at Goal have highlighted a couple of recent abuses of this abusive system here. Um, the first one I want to talk about is a case involving a gentleman, Mr. Novia, who had his license to carry suspended after he called 911 because he was concerned about a potential break-in his home, right? There have been other burglaries in the area. He hears some noises, so he calls 911. The officers come out. I guess he had gone to his gun safe. He had grabbed a shotgun because, again, he was concerned about people breaking
Yeah.
in.
Yeah.
When officers arrive, they ask him, have you been drinking? He says, I had a couple of drinks in my home. They don't arrest him for, handling a gun while he was drunk. They don't arrest him for anything.
Yeah.
But he still has his license suspended, right?
Right. They actually did a roadside sobriety test in one of those breathalyzers.
Yeah.
Which, by the way, I didn't realize until this case that those are not admissible in court because they're so unreliable. However, what they use them for is probable cause. Because if they believe you are, then they can mandate I guess a blood test or
Okay.
one of the more expensive breathalyzers back at the station. But anyway, yeah, he had once the police arrived, he had actually put the shotgun down in the house, came up with his hands up. Hey, I'm the owner. I'm the owner. I'm the one who called you. Da 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 da. And that's when in the interaction, ask him if he'd been drinking. Yeah, I came home from work. I had a couple of drinks. I took a shower, and that's when I was worried. And okay, all right. Suddenly, his license is suspended. Well, wait a minute, for what? Well, he had a couple of drinks in him. So you're telling me if I'm at a backyard barbecue having a burger and a beer and somebody suddenly hops the fence and starts wailing away on my guests, I have no ability now to exercise my Second Amendment? So this is actually a much bigger case than it appears on its face.
Yeah, absolutely. I mean, and again, I mean, how many, I don't regularly imbibe, but, I like a bourbon every now and then. And under those circumstances, I mean, honestly, somebody could really have been breaking into Mr. Novia's home.
Yeah.
Let's say that happened. And let's say that he had to use that shotgun in self-defense.
Yeah.
If they believe that he had a couple of drinks, he should have been able to hold. I mean, is that really the standard? If you've had a beer or two in your home, you're not allowed to touch your gun, even if it's a matter of life or death or self-defense. You can have your license suspended.
Well, oddly enough, Chapter 135 actually put in the legal limit. So it's the same legal limit as driving, and like many attorneys will tell us and have to tell juries, it is not illegal to drink and drive. It is illegal to drink and drive over the limit. And especially now that you have put a limit in law, okay, well, there are standards to follow. But even that, does that apply inside your home? If you're scared for your life, even if you're over the limit, it's a serious question.
Absolutely. And again, I mean, and by the way, because the suitability standards are so vague, this doesn't just apply to alcohol. I mean, if you take an Ambien to help you sleep at night, right? And you wake up in the middle of the night and somebody's breaking into your home, are you under the influence of that Ambien?
Right.
Right. I mean, like this is, as you say, this is, I think, far bigger and broader than people realize. And as egregious as this one is, Jim, I think the other case that you guys are talking about at Gun Owners Action League may actually be even worse.
Well, I think they're trying to outdo themselves.
Yeah. So you've got an individual, his license to carry suspended after an altercation, basically a incident of domestic abuse in which he was the victim.
Yes.
He's the victim,
Yep.
and he gets his license suspended.
Yeah, it was even in the police reports. She admitted the fact. It was a neighbor that called after she saw the wife come outside looking very upset and disheveled. And she admitted to the police right away, no, I hit him. I was the aggressor. He just pushed me away. And it's all over the police reports that she was the aggressor. Judge didn't care. Nope. didn't even want to read that part of it.
Yeah.
And
So
it
in
was
this
like,
case, the guy had his license suspended, and he did appeal, and the court upheld that suspension.
yeah, yeah, yep. It's really bizarre. I mean, you look at the cases that we've had to take since 135 has been put in place. We had to help one young man that he had 6 felony charges of untraceable firearms against him. Cam, the law doesn't take effect till October. And nobody has educated the public on these. He was building his own guns, so they hadn't been serialized or registered yet. But they still arrested him, and that not only 6 counts of untraceable, 5 counts of illegal assault style firearms, which they weren't. They were parts. And in the police report, it was the first time I ever heard the term completed upper. What the heck is a completed upper? It's like, so it's just insane. And we go way back to Kyle Culata
Yeah.
a year ago, and he's still in court for simply driving through Massachusetts while exercising his civil rights. Now, here's a beauty. We haven't gotten involved in this case because the young lady doesn't want her name out there, but it's okay to just talk about it in general.
Okay.
She was driving through Massachusetts, coming from one job to another, and she's she does these jobs for corporates where she goes in and sets up, structures, stores, whatever.
Mm-hmm.
And then her and her crew were heading to New Hampshire. And imagine that a woman of color got pulled over for driving too slow. So, so in the process, they searched the vehicle, and she had a loaded handgun in her purse between her legs on the floor, which under Chapter 135, there is now a very specific okie dokie for. Nope. Put the cuffs on her, charge her with felony possession. So the attorney in the case went to the prosecutor and said, guys, there's a clear exemption. It's in black and white that they can do that driving through the state. So the DA has said, yeah, we know, but if she pleads to a misdemeanor, we'll drop the felony. Whoa, wait a minute. You just said that she was perfectly legal doing what she was doing, but you still want her to plea out? So now she's stuck in a situation of, listen, I want to get on with my life. I don't want to spend $10,000, $20,000 fighting a felony charge.
Right.
Do I plead out? And now I just have a gun charge on my record the rest of my life so I can get the heck out of here. But this is what's happening in Massachusetts. And it was Mike Harris who actually coined the phrase, the process is now the punishment. Even if you get off, your life's destroyed.
Yeah.
And rather than actually conducting an investigation and finding out if you're actually violating the law, they just arrest you, file charges, and make you work your way out of it. And that's just unacceptable.
It is. And when I wrote about these cases at Barry Arms a couple of days ago, I suggested that the Department of Justice, they've been filing these pattern and practice lawsuits around the country.
Yeah.
I mean, if you want a clear example of a pattern and practice of violating people's civil rights, what you just described is you can't ask for a better example of that. Here you have, an arrest for basically a crime that doesn't exist in the state of Massachusetts. Prosecutors acknowledge this isn't a crime, but rather than drop the charges, well, how about we'll offer a plea deal, we'll reduce those charges down to a misdemeanor, right?
Yeah.
You've got individuals, again, the suitability standard, I think, is a pattern in practice. This is not a shall issue system. If licenses can be revoked or they can be denied for you having a couple of beers in your home, for you being the victim of domestic violence, this is not a shall issue system.
No, not even close. So here's another new one that came up between the time we set up this interview.
Yeah.
For non-residents. We started getting emails and calls from non-residents saying, wait a minute, I have to register my guns even though I live in Virginia? And I was like, what are you talking about? So the guy takes a photo of a renewal card he got from the state. Hey, your license is up for renewal. And there's one line in there that says something like, FYI, the mandate to register your guns doesn't take effect till October. So the ones who are paying attention said, wait a minute. So that means as of October, as a non-resident, I got to register my guns. And so I called the state. I know the folks there pretty well. And they said, oh, no, it's the same card that goes out to all of our license holders. They can just disregard that. I'm like, it doesn't say that.
Right.
So now these people are worried about whether they're coming here to hunt or they're carrying or whatever. If I get checked and my gun isn't registered in the state, am I going to jail? And we're like, we have no idea. Because I have argued since day one the risk, because the law says possessed in mass. And the state unofficially keeps telling us, well, we interpret that to mean mass, residents. That's not what it says. And you just backed up the confusion by sending out this postcard.
Right. Good Lord. And this is, again, these are for people who have non-resident permits, right?
Yeah.
Which is already a pain in the neck to get. Do you still have to go in person and drop off your application or sit for an interview in person for a non-resident permit?
They changed that a little bit in 135. It's your first time that you have to. But now here's a problem.
Yeah.
Because the non-residents, the license is only good for a year. It's $100 a year. But it takes you almost 8 to 10 months to get it. And a lot of times the license will have expired before you get the new one. So is that considered a new one? Yeah.
Right.
So people in Virginia have to drive or fly up to Chelsea, Mass to be interviewed and then, go from there. But it's such a debacle. It's crazy.
Yeah. It really is crazy. And, as I said, I think it's a target-rich environment for the DOJ. I know you and I have talked before about, the sad fact is Massachusetts is in the First Circuit Court of Appeals.
Right.
Which at this point may be even more hostile to the Second Amendment than the Ninth Circuit is, right? And so it's a real difficult challenge to file these lawsuits. Even if you get a good win in the district court level, we saw this with Maine's waiting period law. The plaintiffs prevailed at district court. It goes up to the First Circuit, and they say, no, these waiting periods are great. They're fine. Just a commercial limitation on a commercial sale of a firearm. So even if you win at the district court level, the deck is stacked against you at the First Circuit. And it really, if you file a lawsuit, we say this, I guess, ultimately with every lawsuit, but you are really dependent on the Supreme Court taking an interest in your case, granting cert to this case, and otherwise you run the risk of establishing bad precedent, right, in the First Circuit if the court allows these decisions to stand.
Which just happened again with the assault weapons law. So back in 2018 or 16, whatever it was, they ruled against us.
Yeah.
And now an individual on their own filed a case. And I can't blame him to some extent, Cam, because it's his business. But, we always tell people, folks, if we're not doing it or moving it, there's a reason. We have a case before the local federal court that we've stayed on purpose because we're not going to waste a couple of $100,000 to get another bad decision out of the first. Mm-hmm. And as we know, supposedly SCOTUS is going to take this up next year. So both sides, imagine that, have actually agreed, why spend the money and the effort if this thing is probably going to be handled? So, but the problem now, Cam, is it's not happening a lot. I won't try to say that. But people are filing their own pro se cases to the Supreme Court and then getting angry that we won't support their pro se case. We're not going to support a pro se case anyway, because the Supreme Court only takes cases with recognized attorneys that they have approved. So it would be, I think the last time a pro se case got before them was in the 60s. And it probably had to do with civil rights. Who knows? But yeah, it's just insane here. It's no secret. I tell people all the time, since this law had passed, and we were never involved in litigation before. We are now, obviously.
Right.
We have spent almost $700,000 on litigation, and we're not even close to getting a good answer.
Wow. Well, the good news for me, Jim, is that there's always something to talk about. And I get to welcome you to the program on a regular basis. I would trade that for some semblance of the Second Amendment being recognized in Massachusetts. I'd trade that in a heartbeat. And
we asked the First Circuit to list the Bill of Rights by numbers, and they went 1, 3, 4. So, but if nothing else, Mo Palmer says hi. So
well, hello to Mo Palmer. I'm sorry I didn't get a chance to see her when I was up at the goal event back in April, but maybe next year. And Jim, as always, man, keep doing what you're doing. Thank you so much for standing up for Massachusetts gun owners. Goal.org is the website. If folks want more information, Jim and the staff there do a great job of updating the website with these news stories and alerts. So I'm sure we'll be talking again before long, Jim.
Unfortunately, yes. All right, Cam, thanks for having me. We'll see you.
My thanks again to Jim Wallace for joining us on the program. We're going to be talking with Toby Leary tomorrow about the latest in the efforts to repeal Chapter 135. And it really is, I mean, as I said to Jim, one of the problems with the No on 9 campaign is that there is no real simple way to document just how deeply flawed this law is, because the law is so broad and so all-encompassing. It could literally take hours to delve into every one of the issues. But even if you just want to rattle off all of the problems, you're going to be spending longer than 30 seconds, longer than 60 seconds. So how will the Civil Rights Coalition distill their message down to one or two sentences that the voters of Massachusetts can take with them in their mind as they head to the polls this November? Again, we're going to be talking about it with Toby Leary on tomorrow's Bearing Arms Cam and Company. Right now, though, let's turn our attention to today's Armed Citizen story, our good deed of the day, and our recidivist report. We will start there with a case out of Ohio. Former Ohio State football player gets probation after string of robberies. Yeah. Now, I'm not saying it's because Marcus Williamson played for the Buckeyes, but I don't know. I just have the suspicion that if it were you or me or somebody who did not play football for the Ohio State University, maybe we would be getting a different sentence here. Marcus Williamson, who was a cornerback for the Buckeyes between 2017 and 2021, previously pleaded guilty to 9 felonies in relation to these bank robberies, included guilty pleas on 5 counts of second-degree robbery, 4 counts of third-degree robbery, and his sentence is 0 prison time. Yeah, 9 felonies, no prison time. According to Fox 8 in Columbus, Ohio, the charges, which also included the dismissals of 16 additional robbery or theft accusations, stem from 9 different incidents between March and April of last year, when Williamson was suspected of a series of bank robberies in and around Columbus. Court documents stated that Williamson would present a bank teller with a note demanding money while claiming he was in possession of a firearm. He then would flee the bank before getting in a blue Jeep and driving away. His final robbery attempt was at a First Merchants Bank. Police actually showed up before he got away. He was placed into custody without incident. Officers recovered the stolen cash. On Thursday of last week, Williamson's counsel requested probation and rehabilitation. Williamson expressed remorse and regret while reading a prepared statement. I'm sure he did. I'm sure he has remorse and regret. Now, would he have remorse and regret had he not been caught? I think that's a legitimate question to ask. Prosecuting attorneys, victims of the robberies, had asked for prison time because of the repeat nature of these offenses, but a judge ordered that Williamson be granted a reserve sentence while serving a 4-year probationary period. And shall he fail to meet the requirements of his probation, he is eligible for a prison term of between 19 and 21 and a half years in prison. So, if he keeps his nose clean, nothing happens to him. I mean, he will have a felony record, but I think he spent 40 days in jail before he bonded out. And that'll be the only time behind bars that he serves. Judge Cheryl Munson noted during his trial and court appearances that he had stayed out of trouble after bonding out of jail, which is great, but doesn't change the fact that he committed 9 bank robberies and got a slap on the wrist. Among the terms of his probation, he has to complete a specialty mental health program. He will have GPS monitoring. We know how well that works. He's not allowed to enter any bank for the foreseeable future and is required to pay more than $14,000 in restitution. Yeah, okie dokie. All right, on to today's armed citizen story. From Riverton, Utah, where a man who was armed with a shotgun was fatally shot at a convenience store by 2 armed citizens, according to police. Now, this was originally reported. Guy goes into the gas station / convenience store, wants to buy alcohol. Clerk refuses to sell him alcohol because he doesn't have an ID on him. Guy gets very irate. There's a customer in the store who says, "Hey, man, calm down. No big deal. Just, calm down. Go get your ID and then come back and get your beer. No big deal." Guy storms out of the store, comes back a few minutes later. He's got a shotgun. Originally, it was reported that he fired that shotgun once before an armed citizen returned fire and shot and killed him. Police then updated their information to say, well, no, he didn't actually fire his shotgun. And there were actually 2 armed citizens who opened fire on this guy when he walked into the store with a shotgun. Man walked outside in the parking lot where he passed away from his injuries. The 2 bystanders remained at the scene, cooperating with the investigation. Nobody else was injured. And I think under Utah's self-defense law and defense of others, basically their use of deadly force law, this guy didn't need to have fired the shotgun in order for the armed citizens to reasonably conclude that he meant to do great bodily harm, right? These 2 armed citizens were there in the store when the guy originally came in, was denied his ability to purchase alcohol. They saw him get angry. They saw him leave the store. They saw him come back in with a shotgun. I mean, at that point, right, I think it's reasonable to conclude, oh, this guy plans on shooting the clerk, maybe shooting us, but there's a reason this guy just brought a shotgun into the store. So they didn't have to wait for this guy to pull the trigger of the shotgun. As long as there was a reasonable belief of death or great bodily injury or the commission of a forcible felony, they had the ability to act under Utah's use of force law. And I think it was entirely reasonable for those armed citizens to reach that conclusion that their lives were in danger, the lives of everybody in that store was in danger under those circumstances. Finally, today, our good deed of the day, in the right place, at the right time, willing and able to do the right thing. A Florida man who actually saved a woman trapped on railroad tracks in Hobie Sound, the pair reuniting there on camera, as you can see. This is coverage from WFLX, Fox 29. This happened last Friday about 5 o'clock in the afternoon. Debbie Spelstra was driving in Hobie Sound. She made a turn, and all of a sudden, a crossing arm came down on her car and actually trapped her there on the tracks. Her car's antenna was caught on the crossing arm. She said, I just went to turn, and as soon as I turned, the gate came down on top of my car, and then I realized I was trapped, and it was absolutely trapped. So Spelstra's in her vehicle. She says, I know for sure that somebody might come up from behind and help me, but it didn't happen. Then all of a sudden I looked and I saw my guardian angel coming over the track. The guardian angel, a guy named Josiah Bauer, he was on his way home from work. He saw what had happened. He said that the moment, he calls it a lesson because he said he was in a hurry. He needed to get home, but after seeing what happened, he was forced to slow down and help. He said, I looked down on my phone, I looked back up, I see Miss Debbie's car stuck on the train tracks with the arm down behind it. He said, as she's trying to move, I'm like, holy cow, she's stuck on the tracks. She's going to get hit. So I threw it in parking. I just took off running. He was tracking the train that was coming. That's why the arm came down. He said, I was trying to see where the train was, how far off it was, how much time, also which side of the track it was on. And when I noticed it was on her side of the track, I'm like, okay, it's now or never. We got to do this. So he actually lifted up the crossing arm. Spelstra put her car in reverse, backed up just before the train came through. Spelstra said, I don't know how many seconds passed by, but it was a close call. It was very close. Josiah Bauer said it was a close call for him too, but he said it was the right thing to do. He said, don't hesitate to help others when they're in need. He said, I didn't sit there and think about it. I sat there, and if I sat there and hesitated, who knows if I would have got there in time. He said, people say she's a stranger to me, but she's a child of God just like I am. So, again, the pair able to reunite on camera. Spelstra says she wants to take Josiah Bauer and his family out to dinner as a thank you. She also noted just kind of a serendipitous connection. She's got a 9-month-old grandson named Josiah. And she says she will never forget what Josiah Bauer did, calling him an amazing individual, describing him as a selfless, and again, her guardian angel. Said, I'll never forget what he's done ever. I'm truly grateful and indebted to him. So in the right place, at the right time, willing and able to do the right thing to help a stranger in need, Josiah Bauer, there in the Sunshine State of Florida, we thank you for your very, very good deed. All right, that is going to do it for this edition of Bearing Arms Cam and Company. I want to thank you, as always, for being a part of the program. I'm looking forward to seeing you back here again tomorrow. But be sure to check out BearingArms.com throughout the day today, keeping you abreast of all of the latest Second Amendment news and information from all across the nation. And we'll see you back here for a 2-8 Tuesday edition of Bearing Arms Cam and Company tomorrow. Until then, be well, be safe, and be free.